Okay. I want to talk about a much more prosaic issue, what apparently prosaic issue, which is the introduction of written examinations. I must apologise, it's not 1835, it's 1836 and 1837. Now, my argument here is not so much about the examinations themselves, but what they symbolised and why it happened earlier. For example, the bar only introduced written examinations in 1870s. So what was it that led to this development? The starting point, of course, is an argument about who are the attorneys and the solicitors and how were they qualified? How did they get qualified? They obviously date from the medieval period, a time when the craft guilds and all the rest of it were developing sophisticated processes for craftspeople qualifying. But I think the first thing we need to note is the fact that there was, in effect, no formal qualification standard for either solicitors, attorneys or barristers until relatively recently. And I think that, that is the process by which you were qualified was very much a question of either eating dinners at an inn of court or seen to be of good character. Now, the two questions I want to address about this is, what did the introduction of written examinations that we take for granted so much today, what was the implications for the relative power and control and the game players of legal education? I suppose we could say that's the judges, the courts, the inns of both inns of court and the inns of chancery, for professional organisations, and most importantly, perhaps, the universities. That obviously were emerging at about the same time as or in modern format, the modern universities from the same time roughly as the introduction of written examinations. The first question is, therefore, what does it mean for the dynamics of decision making, power, influence, etc.? It's very important, of course, because examinations don't just, of course, decide how many people enter the profession, but it can be used as a device to protect incomes, to protect influence, and all the rest of it. And we have seen that happening. There is no question of that matter. So the first question is, what about power relationships? The second question is very much about, what were the implications of the examination for legal education itself? Who were the examiners? What were the exams like? Who taught the students? Who assessed the students? And what do we know really about the structure of the examinations themselves coming into the 20th century? So why, after decades and centuries of virtually no activity in terms of checking the qualification of people to become a lawyer, a professional lawyer, what was actually the motivation for change? Now, in order to understand this, I think we have to do two things, because the research that I've done is almost exclusively from primary source materials. And by that, I mean the examinations themselves, the papers, the pass rates, the reports, but also the learning materials for students, and of course the influence of professional bodies, but also journals, and of which there were huge numbers in the 19th century. They were widely read. And of course, it is the period of the development of law publishing more generally. So the sources I've looked at are important, and in understanding the motivation, we have to look at the journals. At the time, at the beginning of the 19th century, the huge concerns were about the bad reputation of lawyers. Obviously, we know, and that goes on right through the 19th century, but we have to look at the works of Charles Dickens, perhaps particularly Bleak House and the case of Jardine and Jardine, which dominated that book, and where lawyers are portrayed in a particularly unpleasant way. Compounded with that, we still had, despite the introduction of examinations, the traditional view that the solicitors and attorneys, rather than the barristers, are of a pretty poor calibre. And the man who was very influential, you've already mentioned, the 1846 report into legal education, and the quote by Sir John Stevens was about the lawyers. And although he said there are one or two quite decent chaps who act as attorneys, there were others, he said, whose character would compel me to count the spoons if by accident they gained admission to my house. An incredibly damning comment that not only were they incompetent and a poor character, but possibly even criminal themselves. So the first thing we need to notice about the introduction of examinations is that it was very, very little to do with ensuring competence. It was very clearly to do with improving the image, the reputation, and probably the power and the influence of solicitors and attorneys. The changes had been occurring as in the 18th century, although not quite so closely tied to this particular agenda. In 1739, the Law Society, the modern Law Society, had an earlier state called the Society of Gentlemen Practisers in the Courts of Law and Equity. So that in 1729, that organisation was set up. A 5-year period of articles was formally introduced. And gradually, the attorneys and solicitors began to organise themselves into what we would call today, obviously, law societies, law associations, spread throughout the country. But the critical development was the development of the London Law Society in 1825. And the building of its still very prestigious building in Chancery Lane. However, it is important to remember in terms of game players and decision makers that it wasn't until the 20th century that the London Law Society had in membership a majority of solicitors. There's always been a tension between regional societies and the London Law Society. So the society gradually had some very strong people working at the top of it, and it was determined to improve the reputation. And it decided to do this by introducing written examinations. Now, you might say, well, why written examinations? Couldn't some other way of testing competence, oral assessment, or something like that, couldn't that have sufficed? The answer was no. They looked across at Oxford and Cambridge, which had introduced written examinations at the end of the 18th century, and another group that they felt that were quite treated poorly, which is the apothecaries, who were the forerunners of today's general practitioners, GPs. They had introduced a written examination, and it was firmly believed that this decision was to had improved their public image, their reputation. Now, interestingly, when you look at contemporary sources, there was very little. Two things didn't crop up in discussions. Number one, issues around what qualities, what skills, what competencies actually did a solicitor or attorney actually need, and how could they best be tested? Did it look at, well, what are the learning materials that are available to students? Blackstone's Laws of England obviously dating from mid to late 18th century, were just considered to be hopelessly inappropriate for basic information, and were not the commentaries were not seen as particularly student friendly. So it was not, I think, an argument that the materials were not, or the lack of the materials was not seen as a particular problem. The students had 6 months to prepare for an exam about which they had no information. There were great concerns about the fact that there might be rioting in the streets, and the article clerks were pretty annoyed about this because they had no warning, no sources, no materials, knew very little what was going to happen, and yet 100 of them turned up. Now, interestingly, the Law Society's hall on Chancery Lane. This is very significant because the process of setting up the exam had meant that the examiners came from the profession. The papers were written, therefore, by solicitors and attorneys. The assessors of it were also members of the profession, and the assessment of it took place in the Law Society's hall. Now, I'm old enough to remember when solicitors' examinations were still referred to as the Law Society finals. And so that was very, very significant. So what had happened, therefore, was that the power had changed from the judges to the profession. And so the exam took place. Surprise, surprise, all the students passed the first time. Secondly, the second time, a few were, quote, postponed. Now, when you think about the introduction of examinations, we know that Oxford and Cambridge had introduced written examinations. We also know that in 1830s, University College London and King's College London were about a few hundred metres from the Law Society building itself. And yet there was no contact whatsoever between either the judges calling people together. There was never a question that the examination should be handed over to the universities. And that is very, very significant, because if we ask the question about the ongoing tensions in legal education, I would argue a lot of it is still about the tension between so-called academic law and vocational law. And that has never been resolved. And one could argue that the giving of the, or providing the examinations for the profession being handed over to the profession itself was a very, very significant development. So just moving on very quickly, what I wanted to do was very briefly look at what we know about the examinations themselves. Well, what happened very quickly was that the examination, though starting off a question saying, what do you understand by a fee simple in possession? What do you understand by a trustee? And which you could answer in almost one or a handful of words, but actually they had 5 hours to do this exam. So one is assuming that they had to do something for that period of time. And the exam looked at the conveyancing, probate, bankruptcy, the core subjects of a practicing solicitor or attorney. So the examination started off as, let's not frighten the horses, but let's just have it, reasonably simple. But how quickly the examinations changed. They became much more complex. They made more demanding questions. The number of examinations went from the preliminary, which is like an A-level equivalent, to the intermediate, to the finals, which is what this examination was, and the honours exam. Ever so quickly, a whole edifice was created of interconnected examinations, which became increasingly demanding and had extremely high failure rates. It might be interesting to note that the honours exam, which was the pinnacle introduced in the 1870s, the pinnacle, it was like a master's degree now almost. Students entered that exam, some of whom were graduates and some of whom were not. The students who were not graduates tended to do better for this honours examination. So we have an edifice. We have a set of examinations. We know a little bit about the examination papers. We know about increasingly rising failure rates. We know who was doing well and who wasn't. But what was actually the last area I want to touch on, because I think this is extremely important, is who were the teachers. If the universities, if you look at London University, I mean, I might argue that it's until the Ormerod report, law featured very, very little in university faculties. The number of law faculties was very low, and it wasn't until the Ormerod report at the last century, and secondly, of course, the introduction of polytechnics and the increase in the number of institutions teaching law, that we had a really significant outpouring of legal education. The 19th century was pretty much a desert for the teaching of law in Oxford and Cambridge, didn't do it at all, really. And then even the newer universities, London, obviously University College and King's College. So who were the teachers? The teachers were the private providers. These were the so-called crammers. They had got the skills together to get students through examinations because they were cramming for the civil service exams, the apothecary exams, and they were developing ways of teaching. And I can't emphasize this enough, because we see these as pretty much bottom of the rung, these people who were teaching in the evening, but interestingly, they very quickly introduced what we would call open learning. They were the people who introduced correspondence courses. Why? Because not everybody could come to London or to major centres to learn how to study for an exam. They hadn't got the material. So very quickly, although online was not possible, these crammers were producing their guides to the areas of law. They were teaching at convenient times for students, and they were teaching in a very student-centred way. One of them, of course, one firm, Gibson and Weldon, will probably be well known to most people. Large student numbers merged with the College of Law, which was the Law Society's own teaching arm in 1903. So these people have made a massive contribution to legal education because of the examinations and because of the paucity of facilities outside the crammers. And if you look at the textbook they produced, the way in which they presented law notes, student-centred. They were the first people who thought about legal education being student-centred. They were prepared to collaborate. They were prepared to work in a constructive way. But I just wanted to really finish there in terms of exploring some of the implications of the fact that legal education, as we have come to know it, was founded in the 19th century, but the key providers were not the people today that we think are the main education providers. They were not the universities. There were two strands of legal education, the academic and vocational. They've run parallel, really, for a very long time. And I want to just end on a controversial note. The solicitor's qualifying examination, which has been introduced this year. If you think about how that happened, if you think about the resistance in some quarters, if you think about the concerns that many people have in universities about how you're putting the cart before the horse, and the profession is now arguably has regained some control over legal education that they had lost, I think it does give us pause for thought. I think that's enough. Thank you.